Viewers, welcome to the Personal Injury Law Show. This is a show that talks about everything current in the law of personal injuries and relevant to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer of over 30 years' experience. With me tonight I've got Don Maffia, a partner in a law firm in transport accidents. Good evening, Don.
Good evening, Tony. Good evening,
and
viewers.
we're very fortunate to have Paul Dore, the Juries Commissioner of Victoria.
Good evening.
Good evening, Paul.
Good evening, Tony. Thanks for having me.
Now, viewers, tonight we've got a two-part special on the role of juries in Victoria. Paul, tell us a bit about your background. How did you get the role of Juries Commissioner?
I've been in the public service for the better part of 20 years, and I've been with the Supreme Court for 7 years. And an opportunity came up over 2 years ago, and I was fortunate enough to get the role, and I've been the Juries Commissioner just over 2 years.
Don, generally, what is the role of a jury?
To determine the facts of a case, Tony.
Okay.
So, jury will be impaneled, civil or criminal. They list all the facts and make determination and provide their verdict.
Paul, you see a lot of juries every day.
Yes.
Out the back, you've got a massive room. How many people does it cater for?
It can cater for up to 300. In fact, we've catered on one trial for up to 1,200, not in that room, but across many rooms in this building. We bring in as many people as we know we need for any given day. And some days we don't need anybody, there's no new trials. Other days there may be 9 or 10 new trials starting, and we'll bring in a good bunch of people to cover for that.
All right, now if you're a viewer out there and you're expecting to receive a letter in the mail from your office,
yes.
If they do receive it, what happens next?
They'll receive a letter with an eligibility questionnaire. That eligibility questionnaire determines A, whether they're eligible, B, whether they're disqualified, meaning do you have a criminal record, and if so, you may be disqualified. And if the answer is yes, I'm eligible, and no, I'm not disqualified, then we just need to know if you're available. And you fill out that questionnaire. We send out 70,000 of them in Victoria, 70,000 in Melbourne, about 150,000 across Victoria every year. And from then we will summons people accordingly.
Okay. Don, have you ever received a questionnaire in the mail?
I actually did, when I was a student. But I was exempt because I was studying there. There was exam period. Yeah. But now, because I'm a lawyer, Tony, I'm disqualified to be on the jury.
Well,
ineligible.
Paul, ineligible.
just like Don, Paul, I received one when I was a student as well.
Yep.
And I was ineligible because I was studying law.
Yep.
Who are the people that are ineligible to be on the jury?
There's a bit of a myth around here. About 10 years ago, the eligibility was broadened quite significantly. It used to be that public servants, teachers, pilots, priests, and a whole range of people were not eligible for jury service. Now it's quite narrow. If you work in the criminal justice system, if you're a judge, a police officer, a prison officer, and various others, you're exempt. If you're a practicing lawyer, you're exempt. You're ineligible, and then a number of just very specific jobs, like the Secretary of the Department of Justice, the Ombudsman, the Legal Services Commissioner. So it's quite broad now. Teachers and everyone are back in.
So, Don, effectively, the exclusions are anyone connected with the criminal justice or with the law.
Yeah. And if you are eligible to be on the jury, you must attend. Is that?
You must attend unless you've got a good reason why you shouldn't attend. And we listen to excuses right up until the point that the jury, the individual's going to go into the courtroom. And in fact, judges will then listen to excuses as well. So of those 70,000 questionnaires, we only get about 6,000 people in Melbourne to come in and serve on a jury. So there's a great number of them that are either excused or deferred along the way.
Just curiously, of the 70,000, what proportion would send back the questionnaire saying, can I be excused?
A vast majority. Now, I don't know the exact numbers, but I would say a good 50% of the people. We don't know where those questionnaires are going. The people could have moved, they could be in prison, they could have died, we don't know where they're going. They could be in nursing homes. We often get phone calls saying, you know, I'm 93 years old, why'd you send it to me?
Yep.
You were randomly selected from the electoral roll, and you got a questionnaire.
Don, how many people serve on a criminal jury?
12.
And how many on a civil jury?
6.
Okay. In a criminal trial, what's their role, Don?
Criminal trial, similar to civil trial, again, they just determine the facts. The case is presented to the jury. Could be done by a number of ways, by viva voce evidence or oral evidence, and also might be statements and photographs and all those things. The judge will give the open directions to the jury and ultimately give a charge to the jury as well.
And Paul, one of the most important things a jury's got to do is act impartially.
Absolutely.
What does that mean?
It just means that they have to listen to the facts that are presented in the court with an open mind and make their decision based on the facts that they hear from both parties and the directions that they get from the judge.
Don, generally as a practicing lawyer, one of your biggest concerns is race, religion, colour. These are things that play in your mind. Is that fact or fiction?
Well, Tony, when you're on a jury matter, you're about to impanel a jury. You have a bunch of people that are brought in the jury panel that really all you know is their name, you're told their name and the occupation, and then you have to select your jury. In a civil matter, there's 12 names that are picked out, and then each the plaintiff side has 3 strikeouts and the defendant has 3 as well, left with 6. And there's not much time to do it, Tony. You don't get to ask questions. It'll just be like Tony Carbone, lawyer. And you got to decide just the appearance.
Although they do give your occupation.
Yeah,
occupation.
Just the occupation, but that's all you get.
And sometimes you don't even have the name. So some judges can impanel by number and choose to do that.
Paul, they obviously don't give out addresses, do they?
Oh, no.
Yep. And in criminal trials, do they still give out an occupation?
Absolutely, yep.
Okay.
Yep.
So you could exclude some, if it's a fraud case for argument's sake, you wouldn't want a bank manager on the jury, I'd imagine. Probably not.
Unless he or she can come with an open mind.
You'd think it's highly unlikely, wouldn't you, Don?
Yeah, but even when juries get picked from the pool to go to an impanelment, they get asked, they get told about the witnesses, the type of case, by the judge, of course, the witnesses that will be called, and they'll be asked if they have any excuse not to be impaneled in a jury. So if there's, like for example, in one jury trial that we had, someone in the jury pool knew one of the lawyers that we had with us, so they were asked to be excused, and the judge excused them straight away. So what is initially brought in, all of a sudden is just reduced by half, because a lot of people are excused from maybe they've got some prejudice and have to raise it.
Paul, does the fact that you know one of the people connected with a trial means that you should excuse yourself?
Yeah, we advise jurors, and so do judges once the panel of jurors is in the courtroom, look around and listen to the names, and if you know anybody, let the judge know. It's up to the judge to excuse them, and the judge may think it's innocuous enough that they don't have to excuse, but it's better to be safe than sorry.
Okay. Viewers, we've got to go to a sponsors break. Please stay tuned. After the break, we'll come back with Paul Dore and Don Maffia. Viewers, welcome back to the show. We're very fortunate to have Paul Dore, the Juries Commissioner of Victoria.
Hi, Tony.
Plus, also, Paul, I want to thank you for giving us permission to film within the court. You're aligned to the Supreme Court, however, you're based in the County Court of Victoria these days because of space issues.
Yeah, we suffer a bit of an identity crisis. I'm based in the Supreme Court. I work for the Supreme Court. I'm based in the county court, and 85% of our work is for the county court. 85% of the criminal trials come through the county court. So, effectively, I've got 2 masters.
Okay. Paul, how many staff work under your banner?
We have 24 staff, 11 in this office, and another 13 across the regions.
Don, if your employer, let's say for argument's sake, you get selected to jury service, and your employer says, no, you can't go, it's going to cost you a job. What's the answer to that?
Well, the employer can be sanctioned, I believe fined. Is that right, Paul?
Yeah.
So it's in fact illegal for an employer to say that to a person selected on a jury pool.
Paul, what if someone has just started a new job or they're doing a project that's very important to a particular employer?
Once they have a summons, they have every opportunity to ask to be excused. And I can say with sincerity that we bend over backwards to make sure that people aren't inconvenienced unnecessarily. So a new job starter, we would say, we'll defer you for 4, 5, 6 months. You settle into your job. If you're particularly busy at work, we'll defer you. If you're particularly busy at work 3 or 4 times, we'll stop deferring you and say, look, you've got to make the arrangements to come in.
Okay. What if in your questionnaire you failed to alert yourself to the fact that you are busy or you started a new job? You get selected from the jury pool to become a juror. Can you then stand up and say to a judge, Your Honour, I'm sorry, I'm caught up in a project or I've started a new job? Would you be excused in those circumstances?
It would be the judge's decision whether he or she would excuse the person, but we make every effort to ensure that everybody who comes through the doors with a summons knows that they're there for, on average, 7 to 10 days and have made the arrangements. Now, every now and then somebody slips through, and if they're in court and they want to be excused, they ask the judge, and the judge makes a decision.
Don, it's a very, very delicate balancing act to ensure that it doesn't compromise people's work and their lives and day-to-day activities. And also, jury's role, you can't play it down because we're talking about people's liberty and also people's lives. In a criminal trial, a person's liberty is absolute paramount, and in a civil trial, a person's life is paramount. So it's a very, very important juggling act, isn't it?
That's right. And Paul, if you are, say, picked from the jury pool to be impanelled, you don't, and you have an excuse, say, work, life, whatever. You don't have to. You can write it down and hand to the judge. So if it's personal, a jury member can say, "Well, look, I've got these personal issues," hand to the judge rather than just telling the judge.
And that's often done in trials where there's a sexual offence and a person wants to be excused because the subject matter might be a little too close to home. The judges will encourage you to write it down, and they'll more than likely excuse the person.
Paul, you've just raised a very interesting point. In our day-to-day lives, we're going to be faced with a lot of challenges and certain circumstances outside our control. If you were part of you're assaulted, or if you've been in a bank and there's been a bank hold-up, that's a good reason to be excused, isn't it?
It goes back to that idea of bias and impartiality. If you feel that you cannot listen to the evidence in an impartial way without bias, it is best to tell the judge that. That happens in the courtroom. We don't excuse. When you're in the pool room, when you're dealing with me or my staff, you don't know what trial is ahead of you. So all we're concerned about is your availability and the reasons why you may or may not be able to serve on any jury. But once you're in a courtroom and you hear the evidence, the facts of the case, judges will encourage people to ask to be excused if they feel they carry a bias. So,
Paul, I want to bring an article in here now, refer to an article. There's an article about Dr. J.M. Patel in Brisbane who did unnecessary surgery, was alleged, unnecessary surgery. And there's, from the jury pool, there's a panel selected. And the judge in that case said, is anyone here to be excused due to prejudice or impartiality where because of so much media coverage, and half the jury pool stood up and all walked out. So that could be quite common in these.
The process is very uncommon because that judge actually gave a questionnaire to the panel and talked them through and wanted to make sure they understood exactly what the issues were and do they have a bias or were they influenced by the media, the previous media. In Victoria, we don't have that step, but judges will be very explicit about what the trial is about and encourage people to ask to be excused if it's necessary.
Paul, just on that issue, a lot of people watch the movies, a lot of law shows and things like that. In a lot of instances, you get situations where counsel for the defendant gets up and says, Your Honour, my client can't get a fair trial in this jurisdiction. We want to shift the trial to another jurisdiction. How often does that happen?
It's rare. I have to say two things. One is, if your understanding of the jury system is based on American TV,
you got
get rid of that. Thank you. But secondly, Occasionally, trials will be moved. Do you remember the man who drove into the school kids in Mildura?
Yes. Yes.
Justice Cummins made the decision to move it to Melbourne because he felt that he would not get an impartial jury in Mildura.
That particular case impacted on just about anyone and everyone in the community of Mildura.
Absolutely. I've got family there,
yes,
and everybody
yes.
knew everybody. Yeah.
So
absolutely.
that was probably a very wise move,
yeah.
and he got a reasonably fair trial because I think...
I reckon he did. I was at the Supreme Court as the chief operating officer at the time, and one of the things they did was they broadcast back to the Mildura courthouse. So if you wanted to attend the trial, if you were family, and that it was broadcast back to the courthouse community.
Don, that would be one of the very rare circumstances where a case has been shifted. I can't think of another one in my time in the law.
No, neither can I. And it just goes to show, I guess it's the discretion of the judge. The judge has a duty to make sure that the person who, if it's criminal, obviously has a fair trial, or if it's a civil trial, make sure that the plaintiff has a fair trial too. So I guess at the end it's up to the judge. But there's another case also where it's the sleeping juror.
We've got to go to a sponsors break, viewers. Stay tuned. After a break, we'll deal with the issue of what do you do with a sleeping juror. Viewers, welcome back to the show. If you hear a bit of noise in the background, we're actually filming in a county court. There was a sleeping juror in a case in the Supreme Court.
That's correct.
What were the facts of that, Don?
Well, the fact was it was a murder trial, so the jury was panelled, and in a judge's direction, this is at the start of the trial, just before lunch, a juror fell asleep. And the juror went to lunch, and I think everyone turned around, even at the bar table, barristers said, "We think the juror fell asleep." And one of the barristers for the other, I think it might have been for defendant, got up and said, "You actually heard him snore."
Well, the funny thing about it, Paul, is the judge didn't witness it. He didn't see him sleeping. And one of the barristers didn't see it either. I think the defence barrister saw it, and he alerted the prosecutor and said, "Look, if he's sleeping, we think it's a mistrial."
The trial was aborted in the end,
Yes,
the whole trial. So I had to start all over again.
Paul, what a juror that sleeps?
It could probably happen. I mean, it wouldn't happen often. In fact, that's probably the only time I know that it happened. Jurors come in and they spend a fair bit of time in the pool room, and they may be up and down to court several times. And I would imagine as well that for some people, just the gravity of the situation, the evidence, the lighting, the ambience of the big old courtroom,
Repeating yourself.
It might have just taken its toll on that one person. I mean, I will say that it was embarrassing. Well, at the time, the juror didn't know why the jury was discharged. The judge got a panel immediately after. So while it says the trial was aborted, in fact, the trial was delayed for a couple hours and back on.
Paul, if a jury's discharged, say you get impaneled, jury's discharged for whatever it is, could be 100 reasons why a jury's discharged. They're not told about it. The judge does not tell them as to why they are discharged. But it could be for any reason. In this case, was the jury's just fallen asleep, but it could be because, something was said by a barrister shouldn't have been said, or could have been that there's some sort of impartiality. There's no reason that will give it. No,
the judge will rarely give a reason, and you talked about a lawyer saying something they probably shouldn't have said. That's one of the main ones. So basically, a lawyer just says something that the judge says the jury was not meant to know that, so they discharge and they start over, and we hope the lawyer doesn't say the same thing again with the new jury. But yes, it's the judge's discretion as to whether the jury can continue. Sometimes there's things that occur in a juror's life, so life gets in the way. Somebody might die in the family, and that one juror can be discharged. The judge can make a decision as to whether he or she wants to continue with less than 12.
Okay.
And but sometimes that decision is made to continue, and sometimes it will discharge the entire jury.
Do the parties have a say in whether you continue with 11?
Judges will often ask the parties whether what they're comfortable with.
Okay. Now, a sleeping juror, what does that mean? The person's impartial, not listening, the apprehension that justice isn't being served?
Well, I think the concern was that if the person was asleep right at the beginning of the trial, then it's probably best to discharge that entire panel and start over again. I don't know whether he was sleeping, and I don't know whether, and if he was, I don't know why he was.
Okay.
It's rare.
But I guess the impression would be that he's not actually doing his job properly. That's the simple answer, I think.
Could be.
Yes.
Could be, yeah.
Don, do you know what juries get paid?
I believe if depends on criminal civil and how long it goes for. I think it's $40. Paul, am I correct?
It doesn't matter whether it's criminal or civil. It is $40 a day for the first 6 days, $80 a day thereafter, and $120 a day if it goes for more than a year. But we haven't paid one of those.
So if you're not working and you're looking for a job, don't expect to enrich yourself by becoming a juror.
You won't be retiring on jury service, but the employer is obliged to make up your pay to what you reasonably would expect to be paid, and that includes shift penalties, expected overtime.
Okay.
So it's that idea of what you would reasonably expect to be paid is what your employer must make your pay up to.
And Paul, so let's say you're on the jury, you get picked out of the pool, get impanelled, you're on the jury panel, you hear this case, say it's civil or criminal, hear all the facts, judges gives their charge, jury goes and retires to consider a verdict. What happens then?
The 12, if it's a criminal trial, the 12 people will be in the deliberation room with whatever evidence, transcript, or otherwise they want to take from the courtroom, but nothing else.
Yeah.
And it's important to say nothing else, as in their mobile phones are removed from them, so they can't do their own research, and they are expected to deliberate. And they deliberate for as long as it takes them to reach a verdict. Before deliberations, juries go home at night, come back the next day, go out for lunch, come back the next day, come back after lunch. When they're deliberating, we provide lunch. We feed them until they get a decision, and most go home at night. The idea of being sequestered in hotel rooms is rare now, and they take as long as they need to take to make a decision.
Paul, as long as they need to take, is it 6 hours? Is it 10 hours, or is it up to the judge?
It can be days, and the judge will often at intervals ask the jury, how are you going? You're getting close. Do you need some more time? But it takes as long as it takes, and some decisions are very quick, within an hour, and some are within a day or two, and some go longer. And we had one that was 13 days last year.
And the most important thing is, once they've reached a verdict, they go back into court, they give their verdict, but do they have to give reasons?
They don't have to give, well, in fact, they're not allowed to give reasons. They don't, no,
So
they don't give the reasons. It's guilty or not guilty. And they're not allowed, it's a breach, they are in breach of the act, a juror, if they divulge to anybody their deliberations, what the discussions were that led to the decision.
Well, Paul, in America, jurors do give reasons.
I told you to suspend everything you believe about.
And also, in a lot of instances, jurors have been known to give interviews after the case.
Absolutely. You go on Oprah. Oprah was a juror, and she brought the other 11 jurors onto her show. Yeah, it is very different in the States. You can write a book.
Do you recall the Casey Andrews case in the States?
No, I don't.
She was accused of killing her daughter, and one of the jurors actually gave an interview to news reporters and said the reason why we let her off is because the prosecution confused the case. There was so much scientific evidence that they were confused. They thought there was reasonable doubt. Paul, thanks for coming on board.
Thanks, Tony.
We're going to continue this episode next week. Is there anything else you'd like to add before we go?
If people want to learn more about juries, they can go to our website. There's a pretty handbook there that is that gives a lot of information. And go to our website.
That's it, yeah. Don, anything you'd like to say?
Look, the most important thing is if you are summoned to attend jury service, if you've got an excuse or you have a reason or you want to know more, definitely call the Juries Commissioner.
Viewers, give us your Twitter and Facebook comments on today's episode and any other episodes. Also, stay tuned for part 2 with the Juries Commissioner, Paul Dore. and always remember to stay safe.